Law school exams aren't really about what you know. They're about how you think. And in this explainer, we're going to break down the IRAC method to show you how to stop just reciting cases and start using them as powerful tools for legal reasoning. We're going to turn that knowledge into top marks.
Does this sound familiar? You've memorized dozens of cases. You know the names, the dates, the facts, the whole shebang. But then you get into an exam, you read the problem, and you just freeze. All that knowledge is in your head, but connecting it to the question feels impossible. Well, it's a wall so many students hit, and today we're going to break right through it together.
Look, if you take only one thing away from our chat today, let it be this. Examiners do not want a history lesson. They want to see you think like a lawyer. And that means treating cases not as these old stories to be retold, but as the actual tools you use to build your argument. All right, here's our game plan. First, we'll get into the right mindset. Then we're going to apply IRAC to 3 classic contract law cases to see exactly how it works in the wild. After that, we'll zoom out a bit to really understand the pattern of legal reasoning that underpins all of this. And finally, we'll wrap it all up with some simple, powerful exam strategies you can start using right away. Let's be really clear about this. Top marks are not for memory. They're for reasoning. It's never about just listing a bunch of cases. It's about using the principle from one case to solve the specific problem you've been given. And this right here, this is the difference between a passing answer and a fantastic one. The weak approach, it just retells the story of a case. It's purely descriptive. But the strong approach, it pulls out the legal rule and immediately puts it to work. One shows you can remember things. The other shows you can analyze. And guess which one examiners are looking for every single time? Okay, so let's see this in action. Our first case study is an absolute cornerstone of contract law, Fisher v. Bell. And it deals with that crucial difference between a real offer and something called an invitation to treat. So the facts seem pretty simple, right? A shopkeeper puts a flick knife in his window with a price tag on it. The problem was, a new law made it illegal to offer for sale that kind of knife. All of a sudden, the whole case hangs on one single question. What exactly does offer mean in the eyes of the law? And this just brilliantly illustrates IRAC. First, the issue. What's the specific legal question? Here, it's whether a window display is an offer. Second, the rule. This is that abstract legal principle from contract law, which says displays are just invitations to treat. Third, application. Now, this is where we connect that rule to our facts. The shopkeeper was simply inviting offers from people walking by. He wasn't making one himself. And finally, the conclusion, which directly answers our issue. He was not guilty. See? We didn't need a long story, just the principle and how it applies. Okay, next up, the rules of acceptance. And we're looking at Torres versus Miles. This case is fantastic because it deals with technology. Yeah, a telex machine back then, but the principle is totally relevant to email and instant messaging today. So picture this. You've got one company in London and another in Amsterdam. They're using a telex machine. Just think of it like an old school email. An offer gets sent and an acceptance gets sent back. So the legal puzzle becomes, did the contract form in London where the acceptance was received or in Amsterdam where it was sent? Let's run it through IRAC again. The issue is all about timing. Is acceptance effective when it's sent or when it's received? The rule, which was established in this case, says that for instantaneous methods, acceptance happens upon receipt. Now, this is different from the famous postal rule, which you might know. The application is pretty straightforward. Since the telex was received in London, that's where the contract was made. And the conclusion just logically follows. The contract was made in London. Simple as that. Now, you really want to pay attention here because these are the common exam mistakes that cost students so many marks. They might wrongly apply the postal rule, or maybe they'll just name drop Torres Avantis without actually explaining the principle of receipt. And please, whatever you do, do not waste a single sentence explaining how a telex machine works. The crucial point is explaining why the rule applies to the facts of your problem. Okay, for our third case, we're going to explore a completely different part of contract formation, the intention to create legal relations. And for this, we'll use the classic case of Balfour v. Balfour, which is all about legal presumptions in domestic agreements. The story is actually pretty simple and honestly a little bit sad. A husband promises to pay his wife a monthly allowance while he's working overseas. Later, they separate and he stops paying. So she tries to sue him. The court had to decide, was this domestic promise ever meant to be a legally binding contract in the first place? So let's see, the IRAC framework holds up perfectly.
The issue was this domestic promise, a contract. The rule here is what we call a legal presumption. The law just assumes that spouses don't intend for their personal arrangements to be legally binding. The application, and this is the key step, is where we apply that presumption to the facts. Since this was just a standard arrangement made while they were married and there was no evidence to suggest anything else, the presumption holds. Therefore, the conclusion is clear: no contract, no legal enforceability.
Okay, so we've looked at 3 different cases, covering 3 different legal principles. Now let's just zoom out for a second and see what this actually teaches us about the IRAC method itself, because there's a really clear and powerful pattern going on here. So let's break down this engine of legal reasoning. It all kicks off with the issue, and this isn't some vague topic. It has to be the specific, sharp legal question that the facts are forcing you to ask. From there, you state the rule. Now, I want you to think of this as the tool you're about to use. It's the clean, abstract legal principle you've pulled out of a case. Not the whole story, just the essential legal takeaway. And here we go. This is where the real work happens. Application. Honestly, this is where the marks are won or lost. This is your analysis. You take that rule and you apply it directly to the unique facts of your problem, explaining how and why it leads to a particular outcome. And all of that brings you to your conclusion. This should be short, sharp, and decisive. It's the logical result of your analysis, and it provides a direct answer to the issue you raised right at the start. It completes the whole logical circuit. So the really crucial point here is this. IRAC isn't just some random formula for exams. It's actually a simplified model of how judges and lawyers really reason through legal problems. So when you master it, you're not just learning how to pass an exam, you're learning the fundamental skill of legal analysis. All right, let's wrap this all up with some clear, actionable advice for your next exam. We want to take everything we've just talked about and turn it into a simple, effective strategy you can actually use when you're under pressure. Please remember this, above all else. Quality over quantity. It is so much more effective to pick one relevant case, pull out its principle, and apply it thoroughly than it is to just list 5 case names without any real analysis. Think about it. One sharp tool is always better than a whole box of blunt ones. And so we end right where we began. I want you to make this your mantra. Your goal in an exam is to be a problem solver. Cases are the tools you use to show the examiner how the law works. If you can master this, you won't just be answering questions. You'll be thinking like a lawyer.